Judge Chutkan in the Donald Trump January 6th case is not going to be recusing herself from the trial. She is going to be staying on. Donald Trump wanted to get her off because she's made some prior comments that seem to be adverse to Donald Trump when she was sentencing other January 6ers. But now she's going to be on the case. And we've gone through the prior motions on here, the back and forth about whether she should be off the case. Donald Trump made a whole slew of arguments on favor of this. But now the judge has issued her order and she's not going anywhere. 20 pages. Let's take a look at what the judge says. So she says that, all right, Trump, you don't want me on the case, and now I'm going to be the person deciding whether I go off the case. Kind of a weird system we have. And so now that Donald Trump has called her biased and said that she is not somebody who can give fair decisions in this trial, she's going to review the motion, deny it, and then stay on the case. So all other subsequent motions are going to go in front of this same judge. So she's responding to Trump. She says, oh gosh, Trump, insurrectionist. She says Trump's motion relies on statements that the court made, Judge Chutkan made, during prior sentencings when they were convicted for their January 6th conduct. On that day, the D.C. Circuit has described a mob professing support for Trump. They violently attacked the Capitol, and she's saying here, right, I referenced that case. The rampage left multiple people dead, injured more than 140 people, and millions of dollars of damages. She says over 1,000 people have been charged in this district, and while many of these cases are ongoing, hundreds have resulted in misdemeanor or felony convictions, with sentences ranging from probation to years of incarceration, which again is just like crazy. Think about this. Only hundreds of cases, that's it, in misdemeanor and felony, that's it? Over 2-3 years now? It's pathetic. So she's going to walk us through both of these charges. She says, all right, so there's been hundreds of cases that have been sentenced, and Trump's defense is referring to only 2 of them. It's only 2, okay? So like on most of these that have come through, they're just picking out 2 of them. And she points to 2 of them. She says one that Trump's team referenced was Robert Scott Palmer, and this guy was sentenced for January 6th. He sprayed a fire extinguisher until it was empty. He retreated. She's giving us a background on what happened. In his sentencing memo, Palmer argued that he was a relatively minor participant. He says he went to the Capitol at the behest of the former president, and at Palmer's sentencing, the judge acknowledged Palmer's argument. The judge said, Mr. Palmer argues that his presence was the result of trying to act patriotically, but the court also explained why it did not accept that argument. This is Judge Chutkan. She says, it's true, Mr. Palmer, you made a very good point, one that's been made before, that the people who exhorted you and encouraged you and rallied you and to fight, which is exactly what Trump said, have not been charged. Now, that is not this court's position. I don't charge anybody. I don't negotiate plea deals. I don't make charging decisions. I sentence people. The issue of who has or who has not been charged is not before me. I don't have any influence on that. You see, she's putting this in italics because she's saying, I don't have any influence on that. I have my opinions, but they are not relevant. So these are good statements for the judge. And you're correct in that no one who has encouraged everybody to go to the Capitol has been charged yet, but I don't think you should get a lower sentence. The fact is, there are lots of people who agreed with you who didn't like their results, and you're not being sentenced for your political views. So you have a point that the people who may have been people who planned this and funded it haven't been charged, but that's not the reason for you to get a lower sentence. And so the judge sentenced him to prison 63 months. Same thing happened here. Christine Priola also had a similar thing. She was sentenced at the Capitol grounds. They say what she did, and she said that I had just gotten wrapped up. I had nothing to do with organizing, planning, directing, or leading it, and I played no role of importance that day. And the judge said something when she was sentenced. I see the videotapes. I see the footage of the flags, blah, 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 blah. And this is where she said it's blind loyalty to one person. Who could that be? Who, by the way, remains free to this day, lamenting that Donald Trump is free. There is no mob without members of the mob, I've said before. This is Judge Chutkan. And because they did, because you were there, you're getting sentenced. And she got 15 months of prison. Now, a judge of the United States, they say, this is the legal standard. So those are the 2 things. The Trump defense is pointing to those statements. She says, here's the legal standard. All right. Now, the standard is, she's referencing U.S. law, any proceeding in which a judge's impartiality might reasonably be questioned, any judge shall disqualify himself or herself. That's the standard. Might reasonably be questioned based on those statements. And she walks us through the rules, which we always like to fast forward. She says, justice also demands that judges not recuse without cause. Okay. She's saying that there is a lot lot of recusal to make the system impartial so that we don't have doubts about it. But simultaneously, this cannot be used to harass opponents. And it's got to be more than just speculation or innuendo. And for these reasons, recusal should not be lightly granted. Okay, and she's picking out other cases that support her not getting off the case. Supreme Court has said that different opinions are allowed and blah, blah, blah. But now we get into some analysis and discussion. Chutkan writes, the statements at issue here were based on intrajudicial sources. They did not come from, like Trump says, from watching the news. Okay, they came from intrajudicial, from inside the court, not from outside the court. They came from the sentencing procedures in the two cases we identified. And a review of the law provides some context around why I'm allowed to say this stuff. And she's referencing some other rules here. What are sentencing factors that a court might consider? So when somebody's standing in front of a judge, they can say, Your Honor, I'm the following. The history and characteristics of me show that I need leniency. Or a government might say, no, the public is at risk, so protect the public from those crimes. And these are the factors. And so she says, I'm allowed to talk about these things. When the court considers the severity of a sentence, I can ask about this. I can talk about whether it's minimal or minor. And both Palmer and Priola argued within those arguments. And specifically, they said their culpability for participating in January 6th was minor, and other people have not been prosecuted, like Trump. The court statements from each hearing reflect information that were presented by the defense. So in other words, the defense told us that other people have not been charged, and she says, I know other people have not been charged, but that's a general thing. She's not talking about Trump. In Palmer, the court specifically cited the arguments. They said, good point, right? So she's responding to him, that the purported architects have not been charged. Similarly, they pointed to this, that one person who, by the way, who could she be talking about, remains free to this day. In sum, the statement underlying their motion was based on what the court learned from that case. Therefore, the statements are derived from intrajudicial sources. They came from inside the court. The judge is protecting herself, putting a force field up, saying, I didn't look outside of anything, but it just has to do with what she heard inside the courtroom. Therefore, she can make comments about it. So questions of impartiality, she says, look, even if the statements came from outside sources, they would still not provide a reasonable basis to show that this judge is not impartial. The statements certainly do not manifest a deep-seated prejudice that would make fair judgment impossible, so the judge can set this aside, just like jurors. The standard for recusal has not been met. She says at the outset, Chutkan writing, it bears noting that the court has never taken the position that the defense gives to it. Trump says Chutkan's opinion is President Trump should be prosecuted and imprisoned. She says, that's not my opinion. The defense does not cite any instance of the court ever uttering those words or anything similar. No, you don't think that's similar? Where she said there's one man who has not been prosecuted yet? One man who had not been prosecuted for his conduct. One person who remains free to this day. That's lamenting the fact that Trump has not been prosecuted. She never said Donald Trump should be prosecuted and imprisoned. She never said that. Got that. But everything else to a reasonable observer, you could impute accordingly. Instead, the defense interprets the court's verbal iteration of Palmer and Priola's arguments as relative culpability, suggesting a secret, says the judge, core view about the defendant's criminality. She said that it's blind loyalty to one person who remains free to this day. She says, to begin, the court's statements, what I said, reflect an obligation to acknowledge the sentencing arguments on the record. As already noted, they both wanted lower sentences, and so I had to think about this relative to them. It would be unfair for them to receive a full sentence while others were not prosecuted, was their argument. Now, the court was legally bound to not only consider those arguments, but also to publicly assess them. So I had to consider it. She could have considered them without referencing the one person who is still free to this day, by the way, right? That was her little irritated comment. For every sentence, the court must demonstrate their arguments, and I just had to address it. This is what the court did in those two cases. A reasonable person aware of the statutory requirement that I have to address their arguments would understand that these are not issuing vague declarations about third-party guilt. Instead, they're fulfilling the judge's duty that she has to respond to their arguments that their sentences should be reduced, right? Now, I totally disagree with this because she could have done all of this. She could have actually addressed each one of their points without saying that thing about Trump, about one person, by the way, who remains free to this day. That's her opinion about Trump. And she could have said, well, other people, that is a specific person. She could have said more broadly, look, there are a lot of people may or may not have been charged, but I don't consider them. I only consider consider you. She didn't say that. She could have easily done that, and she didn't. Even on their face, the court statement falls short of manifesting clear and convincing evidence that would support disqualification. Trump's defense here says that the judge said Palmer made a very good point about other people being charged. And she said, I have my opinions about the issue of who has not been charged. But she says that who cares? Even if I was opining that Trump should basically be charged, implying that, the court expressly declined to state who, if anyone, it thought should still face charges. So she's saying, I never said Trump's name specifically. It is the defense. It is Trump's people, not the court, not Judge Chutkan, who assumed that Trump belongs in that group, okay? This is, I never said his name though. This is his defense. This is when your younger brother would put his hand in your room through the doorway and say, but I'm not in your room though. Or when your brother would like put his finger like right here in your face and say, but I'm not touching you, but I'm not touching you, right? I'm not touching you though. She's doing the same thing here, okay? But I didn't say his name. So likewise for the federal sentencing hearing in Priola, Trump purports to detect, he can just opine, an inescapable message in what the court did not say. He can just impute it. President Trump is free, but should not be, is what they're saying, which is exactly what I would take away from her comment. The court did state that Trump was free at the time of the sentence. She did. An undisputed fact. She says, I was just saying facts, but it went no further. So to extrapolate from this is to be hypersensitive. It's to be cynical and suspicious rather than being reasonable. And so Trump's interpretation of the court statement is further weakened when those statements are considered in light of everything else. So she's saying, you know, if you take my one statement out of context, yeah, it might sound bad, but you guys are just being hypersensitive. And when you look at it in context, when you wrap everything else around it, a reasonable observer would clearly know that I am not biased. She says legal precedent also supports this case. Other cases say you really shouldn't recuse yourself. The defense cites only 2 cases, and she says those cases don't apply to me. Analogies in other cases also don't apply, and the defense's remaining citations illustrate a few examples that she addresses and disposes of. And so she's basically just distinguishing her particular case from others. Other instances involve singular and startling facts, but in this case, not at all. The court has from the beginning repeated its commitment to ensure the orderly administration of justice in this case. And this commitment echoes the court's solemn oath to administer justice respectfully. And based on its review of the laws and the facts by Judge Chutkan, who says that she's definitely not biased, the court concludes that a reasonable observer would not doubt its ability to uphold the promise in this case. And for that reason, the motion for recusal of Judge Chutkan is denied by Judge Chutkan. Incredible system we have here, isn't it? So she is reviewing her own work and deciding that she's done a great job, and the case has been decided and it will be remaining with her in her court of law in the District of Columbia. Now, the question is, what is Trump going to do about this? You know, he could certainly attempt to appeal right now, but I don't think that is going to go anywhere. I think what is more likely is that at the end of the case, he's going to have to point to areas where she was in fact biased. One that we've already found is with the multiple Washington monuments that she's requiring Trump's defense to read prior to trial, which is obviously an impossibility. So each one of those little moments where every decision she makes is a problematic decision, Trump's team is just going to be writing those down. All right, biased judge, biased judge, biased judge. Then when he's convicted, there will be an immediate appeal, and each one of those things will go up on appeal. And so we'll see what happens, my friends. Judge Chutkan's not going anywhere. We knew she was not going anywhere. We'll continue to cover. Thank you for subscribing and checking out robertgovea.com to sign up for our daily newsletter, and we'll see you on the next one.